Why don't we go ahead and get started? Welcome to the third and final panel, U.S. Constitutional Levers of Resistance. I don't have much to say by way of introduction for the panel. I think the papers will speak for themselves. Hopefully, then I'll speak to them. So I will just give an introduction for each of our speakers, and then we'll go in this order, same format as previously, work through the papers, do some comments from me, and then open it up to Q&A. The first speaker will be, and this is just going off the program, Ernie Young is the Alston and Byrd Professor of Law at Duke Law School. There he teaches constitutional law, federal courts, and foreign relations law. Ernie is one of the leading voices and authorities on federalism and the constitutional law of federalism. He's a graduate of Dartmouth University and Harvard Law School. We won't hold it against him that he's the only graduate of a non-Big Ten school for his undergraduate, but that's okay. After he left law school, he clerked for the First Circuit Court of Appeals and the Supreme Court, where he was a clerk for Justice David Souter. His paper is titled State Public Law Litigation in an Age of Polarization. After that, we have Doug Laycock, who is the Robert E. Scott Distinguished Professor of Law and Professor of Religious Studies here at UVA and the Law School. It's difficult to overstate his authority in the area of religious liberty, some sense of which is reflected in the fact that his writings on the topic will be published in 5 volumes. In addition to his academic work, Doug has argued a number of high-profile First Amendment cases before the Supreme Court, most recently in 2011, Hosanna Tabor. His paper is The Wedding Vendor Cases, which recently appeared in the Harvard Journal of Law and Public Policy. And finally, we have Adam White, who is a research fellow at the Hoover Institution and the executive director of the Center for the Study of the Administrative State at George Mason University's Antonin Scalia School of Law. His writing focuses on the administrative state, the Supreme Court, the Constitution, and regulatory policy, all of which make an appearance in his paper today. Adam was also recently appointed to the Administrative Conference of the United States and serves on a range of professional committees in this area. He's a graduate of the University of Iowa and Harvard Law School and clerked for the U.S. Court of Appeals for the D.C. Circuit. His paper is titled Serving Two or More Masters, Civil Service and Bureaucratic Resistance in Our Administrative State. So we'll start first with Ernie Young.
Okay, well, I want to thank Rita and the Program on Constitutionalism and Democracy for inviting me to this conference, and Connor for commenting on the paper. It's also a privilege to be on a panel with Doug, who was one of my very favorite mentors in my career. But when Texas Governor Greg Abbott was Texas Attorney General, he liked to say that his job was very simple. I go into the office, I sue the federal government, I go home. Massachusetts AG Maura Healey, who sued the Trump administration 13 times, I think, in 2017 alone, could say much the same thing. And much of the national public law litigation resisting national policy over the past 2 administrations, and going back even further than that, has been spearheaded by states as plaintiffs. And these include challenges to the Trump travel bans, challenges to President Obama's executive actions on immigration and on climate change, as well as to President Trump's reversal of those policies, and of course litigation over the Affordable Care Act. So those suits have been highly effective in many instances, although not all. I don't like the odds for Maryland's challenge to President Trump under the Emoluments Clause, for instance. But there's been a lot of controversy over whether this is an appropriate role for state governments to play. So my paper for this conference is about state public law litigation challenging federal policy and the role it can play in our constitutional system. But in my remarks, I'd like to speak a little more broadly about state governments' roles in resisting national policy. So from the beginning, American constitutionalists have thought of states as a check on the center. Lots of examples here: Virginia and Kentucky's resolutions opposing the Adams administration and the Alien and Sedition Acts, the northern states' resistance to the fugitive slave law, South Carolina's nullification of the national tariff during the Jackson administration, the South's massive resistance to Brown versus Board of Education. One thing these examples show is that when states resist national policies, they may do it in a variety of ideological directions. Sometimes states are more conservative than national policies, sometimes they are more liberal, and sometimes it's just hard to get an ideological valence at all. Even more important, I think states find themselves on the right side of history sometimes, politically and morally, and sometimes they get it horribly, tragically wrong. State resistance can take a number of different forms. So Madison, writing in the Federalist, emphasized the potential for military resistance. This ended up going badly in the Civil War, and many legal scholars seem to think that because military resistance is pretty much off the table these days, the states simply don't play any checking function at all. But I think there's lots of other mechanisms for this. So one would be what my friend and co-clerk Heather Gerken has called uncooperative federalism. So many federal regulatory regimes, benefit regimes, depend on the states for implementation in a lot of pervasive ways. The Clean Air Act, for instance, it has the EPA set pollutant levels, and then the states come up with implementation plans and enforce those plans against private individuals. This leverages federal power and magnifies the federal power, but it also creates opportunities for resistance. Heather and Jessica Bozeman have talked about the power of the servant, the power to put your own spin on interpreting the mandates of federal law, to drag your feet on parts of federal programs that you don't like, or just flat out refuse to do the parts that you really can't get along with. An example would be under the No Child Left Behind program that imposed various forms of federal testing. There was a lot of pushback from state and local officials who thought the tests were infeasible and ultimately forced federal administrative agencies to change the way the program was structured. You can think of this as Adams' bureaucratic resistance, but in state agencies, not just at the places like the EPA. So sometimes the deep state is the state. A second category you might call states on strike. So sometimes state officials don't just drag their feet, they opt out of enforcing federal law in various ways. So federal constitutional law says you pretty much have to let them do this. The anti-commandeering doctrine says that the federal government cannot require states to implement federal law if they don't want to. And because federal law depends on states to implement it in many instances, if they can't get the states to go along with certain things, then either certain aspects of federal law are going to go unenforced, or the federal government may have to cave to the state's demands. So examples would include, under the fugitive slave law, Justice Story held that the state officials could not be required to cooperate and participate in the implementation of the fugitive slave law. I think Justice Story hoped that that would cripple the implementation of the fugitive slave law. Unfortunately, it didn't. The legalization of marijuana in places like Colorado or Washington or California isn't really legalization. It's simply the states opting out of enforcing federal drug policy. And what people count on, I think, is the fact that the ratio of law enforcement personnel in this country is 10-1 in favor of state and local government. And so if the states aren't willing to enforce basic laws against marijuana possession, then they're likely to go unenforced. And so it effectively is a regime of de facto legalization. The sanctuary cities situation, right? President Trump has ordered the states to implement federal immigration law in various ways and threatened to cut off their funding if they do not, and yet the Constitution pretty much guarantees, I think, their ability to opt out of that if they so desire. A third category I would call states as shields. So when states when they opt out, they don't purport to block the enforcement of federal law. They just don't help, right? But South Carolina's treatment of the federal tariff went further. For example, they forbade the enforcement of federal law within that jurisdiction and purported to forbid federal enforcement officials to take part. California has done something more indirect in modern times, but ultimately similar, when it forbids its citizens and businesses from cooperating with federal enforcement authorities under the immigration laws. This seems unlikely to end well for California. It certainly goes over the line, I think, of what the anti-commandeering doctrine protects. So another category I would say is states acting as advocates, and they might do this in a number of ways. So the First Amendment guarantees anyone the right to criticize national policy, but states have certain advantages in this regard. They have a very good bully pulpit. They can get on TV whenever they want and criticize national policy. And more importantly, they have their own electoral legitimacy. If you're speaking on behalf of the great state of Texas or the Commonwealth of Virginia, you have a weight I think, to your opinion that you don't necessarily have if you're the ACLU. The Virginia-Kentucky resolutions are a good example, although they also come with a grain of salt because we sometimes forget those resolutions failed to persuade the country in the short term. In the long term, I think they won out. But I think there's a second and more important effective way, and that is that states advocate by example. So Will argued earlier that the importance of legislative opposition is to remind the nation that alternatives are possible to the government's policy. But states can go a little further than that, right? They can not only say, but this is what the policy would be if we were in power. A state that is run by the opposition party at the national level can actually implement their own policy. This is what my friend Heather calls dissenting by deciding, and that can be a lot more persuasive form of advocacy, I think, than simply making policy arguments. And then finally, states can be advocates in a more legalistic sense, and this is where we come to state public law litigation. So let me talk a little bit more about that. Litigation, I think, is an important form of resistance from the inside, and it appeals to the notion of shared norms. We talked earlier this morning about how it's easier to resist if there is already an ideological commitment to certain principles in place that you're building on. And I think litigation is always an appeal to an interpretation of binding federal law, that this is what we've committed to, and what the national government is doing is invalid under those commitments. And it's a form of resistance that is open to a variety of actors. So private individuals can bring litigation challenging national policy. They can do it in class actions. They can do it through non-governmental organizations. But again, the states, I think, have certain important kinds of advantages. Some of those advantages are procedural. So the central problem, and now this will be the geeky part for the lawyers, but the central problem of modern civil procedure is how to aggregate very broad and diffuse interests. And so when we talk about class actions or multi-district litigation or any number of other organizational standing, for instance, that's what we're trying to aggregate, these broad and diffuse interests in various ways. And probably the broadest and most diffuse of those interests and the most difficult to aggregate is simply the interest in the rule of law, of the government's compliance with law. States, I think, have an easier time establishing their right to represent these kinds of interests, and particularly in these rule of law situations. And they may be more likely to be able to get into court with this sort of litigation. But again, I think the more important advantage is simply the institutional weight that the states have, the democratic legitimacy that they have, the accumulated expertise that they have. It used to be that state attorneys general's offices were not tremendously effective litigation machines, but they have radically increased their institutional capacity over the past couple of decades to the extent that they are formidable. It's fun to watch. I think the Justice Department finally have to go up against adversaries that are basically its own size. So I want to make a broader argument about forms of resistance. And I'm going to use state litigation as my primary illustration. So the paper says there's two ideal types of federalism conflicts. One would be vertical conflicts. This is the classic tug of war between the national government and the states. Will we have one national policy, or will the states be able to go their own way on a given question? But I think to a considerable extent, the national government was built to keep a lid on another kind of conflict, and that's a horizontal sort of conflict. And by that I mean conflicts among individual states or groups of states trying to impose their preferences and interests on one another. And they use the national government as basically an institutional tool to impose their preferences on each other. And the fugitive slave law would be an example of that. I don't think Congress had particularly an interest in having a fugitive slave law, but the problem was they were dominated by a block of slave states that had a very strong interest in having a fugitive slave law and used the power of the federal government to impose that on the northern states. And so it may help to think about state litigation in these vertical and horizontal terms. So I would say the Obamacare litigation was, at least on the surface, a vertical sort of conflict. It was about whether Congress had the power to enact this particular policy, and if it didn't, then it wouldn't impose any particular policy on the states. They would be free to do whatever they liked in that area. I'll come back. It's a little more complicated than that. I'll come back to it. A horizontal conflict, a good example would be the tug of war over climate change policy and the Clean Air Act. So, for instance, in the Massachusetts versus EPA litigation, the blue states challenged the Bush administration's EPA's refusal to regulate carbon dioxide and other greenhouse gases as a pollutant, and sought to impose a requirement that they do regulate. And they're not saying that individual states should be able to go their own way. They're saying this needs to be regulated at the national level. We have the right interpretation of the Clean Air Act. And then, under the next administration, the red states sue and say, no, we have the right interpretation of the Clean Air Act. But yet again, we're going to impose it on the nation as a whole. So I think broadly we can say that vertical litigation seeks to establish that the federal government has power or doesn't have power to assess a certain subject, leaving states free to go their own way if it doesn't. It is ideally agnostic about what states would do with that autonomy if the space is cleared out for them. Horizontal litigation simply fights over the content of federal policy, right? And the Clean Air Act is an example. I would hasten to acknowledge that it won't always be easy to tell the difference between these two kinds of conflicts. So consider the Obamacare litigation, for instance. The argument of the blue states would be that you can't have a national health care policy of this sort unless it's done at the national level. So if you say that the federal government can't do it, you're effectively imposing a policy of laissez-faire or something much less regulatory on the country as a whole. So I think I would say that we have to think of these vertical and horizontal elements as dimensions of these conflicts and not as categories of these conflicts. And many cases will have both dimensions, but I still think it's possible to say in any given instance that one dimension is likely to predominate over the other. And my primary argument then is that these two dimensions of federalism conflicts represent two quite different modes of resistance. So vertical conflict, I think, can act as a safety valve for national conflict. Its thrust is to take divisive issues off the national agenda, allowing different states to deal with these issues in their own different ways. And that works as a safety valve, I think, for several reasons. One is that although we are evenly divided nationally, the contending sides are not evenly distributed geographically. Right? So they can address problems at the lower level because those state governments are less likely to be gridlocked by even division, and you're going to satisfy a significantly higher proportion of the country if you let individual states go their own way. The second reason is many states seem to be less polarized than the national government, and that may be because partisan sorting hasn't gone quite as far. At the state level, you still have conservative Democrats in southern states. You still have moderate to liberal Republicans in northern states. And also because the sides are less closely divided in the states, there's some political science evidence that the closer to the division, the more obstructionist behavior, the more polarized behavior you're likely to see. And then the final thing is that trust in government, which is an important element of bipartisan cooperation, seems to be higher at the state level than it is at the federal level. So horizontal litigation by states, on the other hand, is generally just a continuation of polarized partisan conflict by other means. And so it's an extension of the situation in Washington. That's unlikely to have any safety valve function, and in fact it may escalate polarized conflict. And this isn't to say that horizontal litigation is all bad. It has the virtue of checking certain forms of overreach, especially violations of the separation of powers. Horizontal conflict may be necessary when there has to be one national solution, either just because the issue is so clear as a matter of justice or policy, or because it's the sort of collective action situation where you can only have a situation at the national level. But I think we have to remember there's a cost to this sort of litigation, and horizontal conflict is sacrificing the safety valve function of federalism, and that's a significant cost, I would say. And I think that set of concerns is generalizable from this case of state litigation to all forms of resistance. The question is simply whether a given act of resistance imposes one's own view on everyone else, therefore probably prompting more reciprocal acts of resistance from the other side, or whether you're clearing out space for people to agree to disagree. And I think on many questions, the latter course is going to be better, and that states can play an important role in facilitating that.
Next Next, we have Doug Laycock with his paper, The Wedding Vendor Cases.
Well, first, I very much regret that I couldn't be here for the rest of the conference. The short explanation is it would have been medically imprudent, and we'll leave it at that. Individual rights often protect a form of resistance. It's a right to be different. It's a refusal to conform to widely shared norms. And we have traditionally created strong individual rights with respect to matters that are especially important to the individuals holding the rights. That's certainly not the only reason for creating rights or the only basis for recognizing them, but it's one very important reason. So we protect the freedom of speech, we protect freedom of religion, and we protect what legal doctrine calls family, sexual, and reproductive privacy, by which we really mean family, sexual, and reproductive autonomy. And I believe in all those rights. It is essential to protect freedom of speech. It is essential to protect the free exercise of religion, and it is essential to protect sexual autonomy. So today's paper is the latest statement in a long-running effort to protect the rights of both sides in the dispute between religious conservatives and the LGBT community. Working with a small group of like-minded academics and the occasional activist, we've published articles, written state legislatures and states considering marriage legislation, filed briefs in the Supreme Court, urging all those bodies to protect same-sex marriage and then protect the religious dissenters. And so far, that effort, which if you go back to the very beginning is 15 years, has been absolutely and entirely futile. I want to separate two distinct issues that the political coalitions on each side have generally run together. One set of issues is the right to live your own life by your own values. The right of gays and lesbians to come out of the closet, to keep their jobs and their housing and their access to the marketplace, to marry, to celebrate their weddings. And we're still on the same side here, the same side of the comparison, the right of religious conservatives to adhere to their religious teachings and their moral values and not be forced to participate in activities that violate those teachings and values. And the other side of the comparison is the claimed right to force others to conform to your own practices and values. The long oppression of gays and lesbians by social consensus, of which religious conservatives were a very important part. The failed attempt to prevent same-sex marriage, the continued successful efforts in red states and in Congress to prevent gay rights legislation, the ongoing efforts by many in the gay rights movement to refuse any exemptions to religious dissenters, to force wedding vendors and even nonprofit religious organizations to recognize same-sex marriages and assist with same-sex weddings. Each side's attempt to force the other side to conform escalates the conflict. Each side's efforts to restrict the liberty of the other side is inconsistent with its claim of liberty for itself. It shouldn't be this way, and it didn't have to be this way. In an ideal world that does not exist, conservative Christians and the LGBT community could be allies. They each make essentially parallel claims on the larger society. First, they each say that some aspects of identity are so fundamental they should be left to each individual, free of all government regulation except for the most compelling reasons. Sexual orientation is that fundamental, and for many Americans, religious faith is that fundamental. Second, sexual orientation and one's understanding of God's will are each experienced as involuntary. Sometimes they change over time, but they cannot be changed by any act of will or because the government says they must. Third, each side has faced the argument that their conduct is separable from their identity and that the conduct has no legal protection. So conservative churches and government lawyers said that they had no objection to sexual orientation. It was only sexual conduct that was regulated. And the Supreme Court, in a case called Employment Division versus Smith, said that we all have a right to believe a religion, but only a very limited right to actually practice that religion. Well, both of those arguments are absurd from the perspective of those whose rights we're trying to protect. It is no more reasonable to tell religious believers they cannot act on their understanding of God's will than to tell gays and lesbians they have to be celibate their entire life. Fourth, each side seeks to live out their lives in public, not in the closet. Be a couple in public, present at the workplace as part of a couple, adhere to one's religious obligations and charitable works in daily life, in professions and occupations and in their workplace. And fifth, each side is viewed as evil by many on the other side. One side sees bigotry, the other side sees sin. And so each is vulnerable to intolerant and unjustifiably burdensome regulation in places where the other side can muster a majority. And so in blue states, we have religious people in the wedding industry being sued and suffering huge judgments. And in red states, you can now get married under federal law on Saturday and get fired for it at your workplace on Monday. Each side readily sees all those issues for itself and none of those issues for the other. The two sides also have a very different understanding of what it is they're disagreeing about. Marriage is a legal relationship, a religious relationship, and of course a deeply personal relationship. Many Americans no longer see their marriage in religious terms at all. But for many devout believers, all marriages and all weddings are religious, however the couple understands them. Because for them, civil marriage merely provides a legal frame that implements the underlying religious relationship. So for many of those believers, same-sex weddings are an inherently religious event that is religiously prohibited, a form of sacrilege. And the job of the wedding planner, the caterer, the wedding cake baker, the florist, is to make his part of the wedding the best and most memorable that it can be. They are promoting it, and some of them say they cannot do that. That's why we get these cases about weddings, and we hardly ever get them in any other context. The religious objectors understand the wedding as a religious event, and they don't understand ordinary commerce as a religious event. Resistance to gay rights and marriage equality would be longest and most intense if the conservative believers see not just a public policy they disagree with, but an existential threat to their own community. The litigation and the heavy-handed judgments against wedding vendors pose that existential threat. The Solicitor General telling the Supreme Court that tax exemption would be an issue seemed to pose that existential threat. Why he said that is an utter mystery, because tax exemption is certainly not an issue for decades into the future. But he said it. That statement and each of the wedding vendor cases gets huge play in religious circles, on religious websites, religious newsletters, and religious conversations. The defendant in each of the wedding vendor cases is a martyr in those circles. What we need is strong gay rights legislation with strong religious exemptions. I would exempt very small businesses in the wedding industry. I would exempt religious nonprofits, and I would exempt marriage and relationship counselors. Matching up a same-sex couple with a conservative religious marriage counselor does no good for anybody. Those cases are not about obtaining counseling; they're about driving religious believers out, or conservative religious believers out of the helping professions. And clearly, we will never get gay rights legislation in Congress or in red states without religious exemptions. So there's an obvious deal to be done. But most Republicans don't want the gay rights law, and most Democrats don't want the religious exemptions, and too many on each side would rather have no bill than include the part they oppose, and that's the story of so many issues in our legislatures these days. Now, the gay rights side says, well, when I summarized what exemptions I would support, I guess I left out an important qualification: so long as another provider is readily available, which will be true in pretty much every urban area, may not be true in a few rural communities. But the gay rights side says that even if another provider is readily available, there is a dignitary harm in being refused service, and in knowing that the refusal of service is based on moral disapproval of what you're doing. And clearly that is right. The dignitary harm is real. But the dignitary harm is real on both sides. The religious wedding vendor is asked to violate conscience. He's asked to disrupt his relationship with God, which is probably the most important relationship in his life. Many are left with a profound sense of guilt if they succumb. So the dignitary harm on the gay rights side ultimately comes down to the fact that rejection on moral grounds is deeply offensive. And a long line of free speech cases says that giving other people offense is not a compelling government interest that can justify a restriction on other people's rights. The wedding vendor cases involve conduct, not just speech, but it is conduct that is protected by the compelling government interest test, under state constitutions, state religious freedom restoration acts, or if the gay rights law is not neutral or not generally applicable, under the federal constitution. And finally, there's one way in which the balance of hardships clearly tips in favor of the religious dissenters. Same-sex couples, even if turned away or referred to another business, same-sex couples still get to live their own lives by their own values. They will still be married, they will still love each other, they will still have their occupation or profession. The wedding vendor does not get to live his own life by his own values. He either has to permanently surrender conscience or permanently surrender his occupation. The baker in Masterpiece Cake Shop, the case in the Supreme Court, gave up 40% of his business. He doesn't do wedding cakes anymore. That permanent loss of conscience or profession clearly outweighs the one-time dignitary harm to the couple. Now, Reva Siegel and Doug DeJame at Yale argue that the demand for religious exemptions is a form of resistance in another sense. Not just that it resists conformity to social norms, but also that there's a way of continuing to agitate the underlying issue. Those who want religious exemptions from assisting with same-sex weddings really want there to be no same-sex weddings at all. And there's something to that as a descriptive matter. Back when marriage equality was a live issue in state legislatures, many on the religious side viewed religious liberty as just one more argument for killing the bill. I once got called by a reporter for Christianity Today, which is one of the leading evangelical magazines. And I said to her, lots of people on the gay rights side think this religious liberty argument is just a smokescreen for opposing same-sex marriage. And she said, well, that's what it is. And for many people it was. But, as they gradually and then finally lost the argument on the marriage issue, more of them came to see the independent value of the religious exemptions too little and way, way too late. Having lost on the underlying issue, they no longer had any bargaining leverage. They no longer had a way to get any kind of religious exemption in blue states. There's still that deal to be done in red states. Whatever accuracy that a DeJame and Siegel account may have descriptively, nothing follows from it normatively. People who exercise their right to political speech by opposing same-sex marriage do not thereby forfeit their right to religious liberty or their right to claim regulatory exemptions for religiously motivated conduct with respect to same-sex weddings or anything else. And conversely, people who assert their right to religious exemptions do not thereby forfeit their right to political speech on the underlying policy issue that they seek exemption from. You can't be forced to surrender one right as the price of exercising the other. Now, there are only a handful of these wedding vendor cases actually litigated across the country. The pressures of the marketplace, the pressures of retaliation, consumer boycotts, and some of these businesses have suffered defamatory reviews on Yelp and other websites. Some of them have suffered vandalism. There are enormous deterrences. You have to feel very strongly about this to actually stick your neck out and claim the exemption. Most of that handful of cases have been litigated under state law in blue or purple states, and the religious side has always lost. Masterpiece Cake Shop has a viable federal theory in the Supreme Court. The free speech argument has gotten most of the attention, but as the oral argument showed, it is hard to place any boundaries on the free speech argument. I spelled out the free exercise argument in the paper, and we spelled it out in an amicus brief in the Supreme Court. It could lead to a much narrower decision focused only on weddings. I think the odds are against the baker. It is not inevitable, but it is likely that this too will be up to Justice Kennedy. As I tell my students, leaving everything up to Justice Kennedy is a hell of a way to run a legal system, but it's the legal system we seem to have. And he remains unpredictable. So time will tell. But I wanted to focus orally on the big picture and not on the nitty-gritty of the argument within legal doctrine. We teach our children that America offers liberty and justice for all, and we could still provide that, but we're not doing so well on the part about for all. It's a matter of mutual tolerance and political will, but too many of us want liberty and justice only for our own side in the culture wars, and that is what I've been railing against for 13 years now. Thank you.
final paper is Adam White's, the title of which is Serving Two or More Masters, Civil Service and Bureaucratic Resistance in Our Administrative State.
Great, thank you. And just to reiterate the sentiments of the previous speakers, thank you so much for organizing this conference. It's such a pleasure to be here. Jim Caesar and I are both affiliated with the Hoover Institution, so where better to start than by quoting one of our more famous or illustrious colleagues, Neil Ferguson. There's an interesting little anecdote in Ferguson's new biography of Henry Kissinger. This is before Kissinger ever goes into government, but his friend Schlesinger, Arthur Schlesinger Jr. is in the Kennedy administration. And Schlesinger comes up to Harvard to visit his old friend and colleague and sort of talk about what's going on. And Kissinger's surprised to find Schlesinger just depressed. It's a year into the Kennedy administration, and Schlesinger is already browbeaten and defeated. And Ferguson quotes Schlesinger's complaints. He says, the bureaucracy has an infinite capacity to dilute, delay, obstruct, resist, and sabotage presidential purposes. This is in summer of 1962, so just a year and a half into the Kennedy administration. After just a year of energetic reform, Schlesinger says, the ice is beginning to form over government again. The press, the Congress, and tacitly the bureaucracy pick off the new frontiersmen one by one as if by ambush. And it's such an interesting story. Here you have Arthur Schlesinger, right, who spent his career celebrating the New Deal, celebrating the creation of this entire modern 20th century bureaucratic apparatus, all the agencies, finding himself in the Kennedy administration ruining the power that the bureaucrats had over presidential energy. Of course, Schlesinger and Kennedy weren't the first to complain about bureaucratic inertia or resistance. Kennedy's predecessor, Ike Eisenhower, inherited this entire bureaucratic apparatus that FDR and Truman had spent 20 years creating. Ike came to office very suspicious of the bureaucracy that he had inherited and found not nearly enough success, in his opinion, in reorienting the government towards his policies. Of course, Truman himself was frustrated with the bureaucracy before Ike was, and near the end of his administration, Truman sort of laughed a little bit at what General Eisenhower was about to get himself into. There's a funny anecdote where Truman is joking with colleagues or with his staff, saying General Eisenhower probably thinks he's going to show up on the first day and order this, order that, and all these things will happen, when of course none of it will happen, and General Eisenhower has no idea what he's getting himself into. And of course, perhaps the most ironic complainer of the bureaucracy is FDR himself, who, in an attempt to build an energetic New Deal, was so frustrated with the lethargy of the bureaucrats that he inherited, so much so that he tried to create new agencies wherever possible to staff with energetic new people rather than subject himself to the lethargy of the bureaucracy. But we can go on like this over and over again to the very beginning, in fact, literally the very beginning. Quite possibly the first bureaucratic resistance to a president was undertaken somewhat successfully by the founder of this university, Thomas Jefferson, who was Secretary of State, spent time campaigning through the press against President Washington's endeavors at the behest of the Treasury Secretary, Hamilton. So this story is as old as the Constitution itself. And you tell these stories and you want to make clear at the very outset, we need to make clear that there's a difference between mere inertia and resistance. The presidents I just quoted complained about both of these things. And of course, bureaucracy is inertia. Sometimes that's part of the point. And we should take care not to mistake inertia for resistance. These are two different things. Sometimes there's a risk that we overstate the problem of resistance in government. James Q. Wilson, in his famous book on bureaucracy, has a nice line. He says, what's surprising is not that bureaucrats sometimes can defy the president, but that they support his programs as much as they do. Wilson tried to downplay this idea of bureaucratic resistance. It was a surprise that doesn't happen more often. But of course, resistance does happen sometimes. We may be seeing it right now in the early years of the new presidential administration. And so I wanted to focus a little bit on why these things happen and how these things happen. In fact, the last year or so of the Trump administration, the last year, namely the first year of the Trump administration, has been perhaps the most highly publicized examples of at least the threat of bureaucratic resistance, especially in the Environmental Protection Agency. Now, as you may recall, the EPA was perhaps the most energetic and successful and consequential agency of the Obama administration. Especially after the first 2 years of Obama's first term, the EPA really became the de facto leader of national energy policy, riding herd on all the other agencies. And the EPA managed to drive energy policy through its regulations. And so as soon as President Trump was elected, even before he was inaugurated, you began to see protests, and we saw a lot of protests, but you saw protests specifically with respect to his energy policy. Even protests at the agencies themselves. There were walkout protests in the regional offices of the EPA, where current EPA staff would go into the streets and join the protests, denouncing the policies of their upcoming leader, President Trump, and whoever he wound up nominating to be the head of the EPA. I jotted down, the paper has a couple of quotes. I'll just read a couple of them. President Obama's last EPA administrator, Jean McCarthy, she had an interesting quote after they nominated Scott Pruitt to be the first EPA administrator under Trump. She said, "It's fine to have differing opinions on how to meet the mission of the agency," and I'll return to that point later, the mission of the agency. She said, "Many Republican administrators have had that, but here for the first time I see someone who has no commitment to the mission of the agency." The president of the Union of Concerned Scientists says, "EPA is composed of civil servants who have been there for a long time and believe in the mission," that word again, the mission of EPA, and believe in the work they've done. I don't expect they'll go quietly into that good night. And so you saw this mix of threats of resistance, two types of resistance, either passive resistance, this idea that the bureaucracy would not assist the newly elected appointed leadership on these policies. But you also saw threats of active resistance, threats of leaking information, threats of protesting, and both types of resistance are interesting. I'll return to that later. But we saw threats of both kind. Now, we're only a year into the administration, so we don't actually know whether this will amount to anything. We don't know if this is just a line from Shakespeare's a tale full of sound and fury signifying nothing, right? This might be empty threats that don't amount to anything, but it might be more than that. And there's a good reason to think that this resistance in the current administration will be successful. There's a good roadmap of it from the last Republican presidential administration, the Bush administration, where you saw a lot of ongoing resistance within the EPA again, and with some measure of success. If you rewind back to when President George W. Bush took office, once again you had he inherited a very energetic EPA. President Clinton had just signed the Kyoto Protocol on climate change. He hadn't submitted it to the Senate, but you could see where the arc of history, so to speak, was headed on this issue. And so as soon as President Bush came to office, you saw complaints from within the EPA and elsewhere in the Bush administration bureaucracy complaining about the Bush administration's refusal to regulate greenhouse gas emissions, the litigation that Ernie referred to a moment ago. The Bush administration suffered a constant stream of leaks from within the EPA and elsewhere, leaks that helped propel the basic narrative that the EPA leadership appointed by Bush was politicizing science and was refusing to acknowledge the real science supporting the theory of global climate change fed by greenhouse gas emissions. After years of the fomenting of this narrative, there was the case that you referred to earlier, Mass v. EPA, where Massachusetts and other states sued the Bush administration to force the EPA to move forward on greenhouse gas regulation. And it's the legal opinion that the Supreme Court issued backing the challengers and against the Bush administration, it only really hints, I think, at how deeply that debate all the way to the Supreme Court was informed by the debates, the broader debates that were driven by the leaks out of the Bush EPA, where the scientists and policymakers inside the agency were so successful at pushing this narrative of the illegitimate politicization of science that I think really fed energy into the Supreme Court's work. Now, you don't have to take my word for it. There's an interesting book that came out a couple of years ago by one of the lead bureaucrats in the EPA at the time. Her name is Margot Oge. She ran the automobile unit of the EPA for years and years before retiring. She released a memoir called Driving the Future, which I think is actually sort of an unintentionally telling hint at the mindset of some of the bureaucrats, the idea that they were the ones driving the future. And she tells the story about how difficult it was to be in the EPA at the time of the Bush administration's leadership, how so many of her colleagues were either slow-walking the work, cheering against the administration, leaking, and it all comes to a head the day that the EPA lost Massachusetts versus EPA. The bureaucracy threw a party inside of the EPA with champagne, celebrating. They said, I quote in the paper, they say, we won, which is remarkable. They thought of themselves we as alongside the challengers bringing the lawsuit. Even the lawyer, the career lawyer who very honorably wrote the legal arguments in favor of the Bush administration, was the one telling everybody, we won, which was a really remarkable window into the mindset. I think it's an interesting case study. Again, I don't want to make too much of it. It's an interesting story precisely because it seems so exceptional. But I think there's a few lessons we can draw from this and similar incidents from, say, the Reagan administration, where you saw pushback in the Office of Civil Rights of the Justice Department and elsewhere. A few common lessons we can draw. One is that while bureaucratic resistance is usually thought of in terms of passivity, of just the refusal to go along with the program, that actually there is an opportunity for real active resistance in terms of leaking information that helps shape the narrative, that shapes the politics, that ends up forcing the hand of the administration, or at least thwarts the administration's policies. And in fact, I think that the court's handling of the litigation involving climate change and other EPA cases shows that actually the act of leaking information out of the agency can be extremely useful in subsequent judicial review, because it signals to the court that the agency being challenged is not unified on an issue, that there's a disagreement between the what you might call the experts, right, the career officials, versus the mere politicians, and both of those terms I want to put in sort of implicit quote marks. But that's the basic storyline that I think feeds very well into the interests of judges in reversing a lot of these policies with which they disagree with. But the court's only one of several constituencies that, or audiences, that the resistance movement inside of an agency either serves or speaks to. The most important one is probably the party opposite the president in Congress, where leaks from a bureaucracy can help support congressional investigations, can help trigger investigations, help give a counter-narrative again of agency expertise versus politicization. Other constituencies or audiences include the media, but also surprisingly, or maybe surprisingly, is the regulated community. Of course, companies or individuals who are regulated by government, in many ways they like to see the reduction of regulation, but not always. They also have interests in stability from government to government. They have interests in being able to make long-term plans that require stability. And so a wild fluctuation of policies from one administration to the next is not always in the interests of the regulated community, even if they might, in a general sense, like some measure of deregulation. And so we see some of this again in the climate policy area, where you have major corporations like Exxon and others already pretty clearly looking beyond the horizon of this administration and calibrating their climate change policy, or they're calibrating their activities that implicate climate change, not in terms of the current temporary, they see, policy of this administration. They're trying to figure out where the arc of history, so to speak, points in the long term on climate regulation. And so the bureaucracy in leaking against a policy they dislike can signal to the regulated community that it's good for them to just stick with what they're doing, because in the long run, the policy is going to wind up in a place far different from the current administration. So what's underlying all of this? A few things, and I sketch them out in the paper very briefly. I think part of the story is a story of the transformation of the civil service, right, from a very elite institution in the era of Washington and Jefferson, to then a transition into a system of political spoils, begun in some measure by Jackson and onward, where the bureaucracy did not just identify with the political party, but were expected to serve the political party of the president, and who helped fund the political campaigns of their party. But then the transition ultimately to one of neutral competence, one of technocratic neutrality, one in which the bureaucracy no longer identifies with sort of the elite of presidential politics or with party politics, but rather identifies very squarely with their agency. a mission that they themselves define within the agency. And I think that has helped explain some of the increase in bureaucratic resistance. But tied to that word I keep coming back to, mission, right? The ability of a bureaucracy to conceive of what they believe is the mission of the agency is a function of the statutes that Congress writes. And where Congress has spent the last 70 years writing statutes in ever broader terms, delegating ever broader powers to the agencies, or sometimes giving the agencies competing or contradicting mandates, such that the agency has some latitude to sort of pick and choose what they're going to do. That enables the agency to become the author of its own mission. So all those quotes that you saw, and I quoted a couple of them in the press, where you had people saying that Trump and Administrator Pruitt don't believe in the mission of the EPA. Mission according to who? Well, in part according to a president, in part according to Congress, but in part mostly according to the bureaucracy, which has been given such broad discretion by Congress. And so I think the overdelegation of power is another one of the stories underlying the current trend of bureaucratic resistance. And then the last story, and I already alluded to it a little bit, is the shift in administrative law, driven primarily by the Supreme Court, also by the D.C. Circuit, that in the words of Jody Freeman and Adrian Vermeule in an article about 10 years ago, they said it was a shift from politics to expertise, right? Where so much of modern administrative law, from especially the bubbled up during the Reagan years, is written in terms of deferring to agencies because they're more politically accountable than the courts. Now there seems to be a shift, at least in key cases like Massachusetts versus EPA, towards the courts prioritizing expertise over democratic accountability. And that's a narrative or an ethos that really advantages the bureaucracy over the political leadership when the bureaucracy starts to resist on a policy. In the course of thinking this through and writing this paper, a few questions arose to me, arose in my mind that I allude to in the paper and hope to pursue in other projects. Just a couple of broad themes. Let me touch on them briefly. The first, as I just said, is this idea of stability versus democratic change in our modern administrative state. You recall that all the anecdotes I began with were Democratic presidents. Well, not Eisenhower, but Kennedy, Truman, FDR complaining about bureaucracy. Right? It's not exclusively a sort of Republican or conservative fight with the bureaucracy. Even Obama at times was frustrated with bureaucracy. And in fact, James Burnham, the great conservative thinker of the mid-20th century, in his book Congress and the American Tradition, not Congress and the Administrative Tradition, I guess that's the 21st century book. But in Congress and the American Tradition, Burnham talks about how the bureaucracy can be a useful diffuser of power at the federal level. Not ideal, you'd rather have it done through Congress, but Burnham saw the value of stability. And I think that still holds true today in some sense, that bureaucratic inertia and resistance does, for whatever costs it might bring, it does promote stability, which has some value. We just spent 8 years hearing about complaints of regulatory uncertainty under the Obama years. That was a conservative critique of Obama, but of course it cuts both ways. Regulatory uncertainty occurs whether you're increasing regulation or decreasing it. And so I think there needs to be some thought dedicated to the value of stability across administrations that can be aided by bureaucratic resistance. The second question, which I already alluded to, is the tension between expertise and politics in modern administration, but also the fact that so much of what agencies do is not a matter of expertise, it's a matter of value choices. Value choices, it's one thing to say that the existence of climate change is a scientific question, right? It's another thing to say that picking the solution to climate change is a scientific question. No, it's a policy, it's a value choice as much as it is a scientific question. And so I think there needs to be greater attention paid to how to allocate that authority within the agencies. Just really briefly, a couple last points, because I know I'm up on my time. Just in the stories I've told briefly, or that I talk about in the paper, my paper's titled Serving Two or More Masters. Right? There's other obligations that bureaucrats face, professional or ethical obligations. I was struck in watching the current debates over the idea that lawyers inside of an administration might be resisting political leadership. That actually raises profound questions about legal ethics. I gave a talk on this in Texas last fall at a federal society conference. I have a short paper coming out just pointing out that lawyers within an agency that are trying to thwart their agency, in some cases are actually violating their own ethics as lawyers, something which shouldn't be given short shrift. And that those obligations are also important to people within agencies. And then I guess the last point, just very briefly, is and I end my paper with this, is just observing the advantage that progressive presidents have in creating new agencies. Right? FDR created new agencies so he didn't have to deal with the old ones. President Obama created some new agencies. He was able to staff them in the first instance, like the Consumer Financial Protection Bureau, an agency that's going to be shaped almost permanently by its initial hirings, right? The people that it brings in as civil servants, and the mission that they define for themselves. That will go on long beyond the Obama administration, the Trump administration. It's an advantage that Republican presidents tend not to take advantage of because they don't like creating new agencies. So as I say in my paper, maybe Republican presidents frustrated with bureaucracy should talk less about eliminating old agencies and more about creating new agencies that trump the old ones. But thank you very much.
All right, thank you for 3 wonderful papers. Actually came in ahead of time, so my goal is to not give back most of that time, but I do have a lot to say, in part because it's very difficult to connect these papers. I'm not even going to try. I thought today, actually, of the one thing that does connect them, that the common thread or the common shadow in all of them, in some way, is the Affordable Care Act. It brings up issues that are relevant to at least the questions, if not the substantive issues. And it's actually 8 years to the day that the ACA was signed. And that says a lot that so many of these questions in that short period of time have implicated these fundamental constitutional questions. But that's as close as I can get to connecting all of them. Instead, what I hope to do is to raise a series of questions for all of them, at least one of which will be critical for each, and then to try to work towards how these papers speak to and clarify the idea of resistance or dissent within a constitutional system and within our constitutional system, to try to clarify how they have helped us. And purely coincidentally, they have arrayed themselves in the order that I'll talk. And it moves in order of where these papers are. One has been published, one will soon be published, and one is still is working its way towards publication. And the questions will reflect that. So I think I have, depending on time, about 3 questions for each author. So I'll start with Doug's paper, which was explained very well, and I'm happy that he avoided the nitty-gritty doctrinal details, because my question is, what does this jurisprudence look like? How can a stable jurisprudence be constructed that takes account of this many criteria? He touched on it, but as I see it, there are at least 3 important moving parts in his solution, in his big normative argument in this piece, which is finding a way to both protect the rights of religious minorities and sexual minorities. The first component is the context. So in context not directly related to the wedding or the marriage or the sexual relationship is one of them. The other is a distinction between large and impersonal businesses versus very small businesses where the owner will be personally involved. And the third is personally involved in the provision of services. And my reaction to this, I think that's it's a helpful beginning, but I don't know what this looks like doctrinally. You know, you're the expert in this area, so I wanted to hear how this will play out or develop in your mind, because much rides on whether this is in fact possible, especially given that the test needs to be responsive to local circumstances. And that was touched on, and it's the qualification that you made in the caveat of whether this is whether there is another provider. And so at what level is this jurisprudence taking shape? Can we expect this, given the history of similar doctrinal frameworks like this, whether this is in fact durable? Because the distinctions and line drawing that are entailed might provide a way to resolve particular disputes in the short run, but I don't know how durable that resolution could be, nor whether these doctrinal formulations can withstand the pressures of social and legal change. So that's the first question about the jurisprudence. The second is whose dignity or what dignity matters. And this was also raised in his description of the argument. And I'll read the passage from the paper. This is 64 to 65 in the published text. Even in the typical case, when another wedding vendor is readily available, same-sex couples understandably complain about the dignitary harm of being turned away and of experiencing the first vendor's moral disapproval. That emotional harm is often real, but it cannot be considered in isolation. We must also consider the dignitary and emotional harm on the religious side. I think he's right to pick up on this conflict, but I'm not sure that the dignitary interests are quite as balanced or parallel as they're expressed here. This is in part because of how the dignitary interests have developed to this point in the different bodies of jurisprudence. In the gay rights context, the dignity interest seems considerably more expansive than it does in the free exercise context. Here are two passages from, of course, Justice Kennedy, first in Hobby Lobby and then in Obergefell. So Hobby Lobby is the contraceptive mandate question, free exercise. There, Kennedy wrote, "In our constitutional tradition, freedom means that all persons have the right to believe or strive to believe in a divine creator and a divine law. For those who choose this course, free exercise is essential in preserving their own dignity and in striving for a self-definition shaped by their religious precepts." And then in Obergefell, a couple years later, he wrote that the plaintiffs now ask whether a state can deny to one who has served this nation the basic dignity of recognizing his New York marriage. And finally, in the final paragraph of that decision, the plaintiffs ask for equal dignity in the eyes of the law. The Constitution grants them that right. And I always like to remind people that the headline to the New York Times the day after Obergefell was two words, equal dignity, and it was also in quotes. So it portrayed some of the novel provenance of this. So dignity in the gay rights cases seems more than just emotional harm, which I think you acknowledge when you contrast it or put it alongside. You say dignitary and emotional harm, as if the dignitary harm and interest adds something to the emotional interest. On the gay rights side, it includes recognition and standing in a political community. For free exercise, on the other hand, the interest is much narrower and rooted in autonomy, I think, which harkens back to an older understanding, still Justice Kennedy's understanding, but an older understanding of that dignity. So in my more cynical moments, I have a hard time seeing how the dignity interests of gay couples, as currently articulated, could square with the dignity interests of free exercise. So puzzling through that question, to the extent that, or so long as dignity remains a touchstone in this debate, how parallel are those concerns? And that brings me to my final question. And you went through this in some detail, so I can skip through some of it. You argue that the claims on both sides are essentially parallel, and that should help us understand it and then come to some resolution in balancing. And I think that that's actually the problem. I think that the problem is that they are parallel, and they are so similar in some respects. So Doug argues we could protect both religious minorities and sexual minorities if we were serious about civil liberties. They make essentially parallel claims on the larger society. This has to do with the fundamentality of the belief, its relationship to identity, how it's involuntary, how they're treated and viewed by the broader culture. But again, I think it's the parallel nature of the claims that are the central problem. Not only are there different dignity interests involved, but there's a difference in how they understand their opponents. You say conservative Christians claims to liberty are impeached by their hostility to liberty for those they disagree with. I don't know if that's the case because I think they're making claims that might in fact be incommensurable. That the interest one has in acting on the religious convictions versus the interest one has in being treated as a full and equal member of a political community can't be balanced, at least not in the long run. And that further relates back to this question of how does a stable jurisprudence take root, or a jurisprudence that is not just transitional, because I do think the stakes in some of these cases are in fact existential, as you noted for some of these communities. So those are my three questions there. That's okay. Moving to Ernie's very good paper on state public law litigation. he didn't dwell as much on this, on the first component as a central argument, but I took it to be one of the central arguments and contributions, is the argument that litigation can serve as a safety valve, specifically, as he clarified here, vertical litigation. And I want to push back on that. I think it's largely right, but I think there's some important qualifications that need to be registered. And it boils down to the question, for whom? From whose standpoint is this true? It seems to me that it's only true for national losers, for those who are losing on the national stage. That is, it seems plausible only from a national perspective, that to reduce polarization and the attendant gridlock, which Ernie traces out very well, this gridlock that we see in the aggregate, that subnational units should be granted some measure of autonomy. But consider the perspective of an individual, a citizen whose state government is contesting national power, especially if that citizen is allied with the national power that is then being obstructed or changed, and that the decisional authority is shifting. The difference between those two cases of the national perspective versus the citizen perspective seems to call into question how we conceptualize the federal system, especially to the extent that if the genius of the federal system is splitting the atom of sovereignty and creating two political capacities, allowing states to dictate this, I don't know if the safety valve gets us what we actually do want. So perhaps in the short term, the litigation could do this, but if successful, it could also set up future higher stakes conflicts. And as you note, it could catalyze and attract opposition, perhaps exacerbating polarization in the interim and actually changing the shape of the problem as it's articulated in the future. So litigation that preserves or expands state autonomy may manage polarization, but it certainly doesn't reduce it. In the long run, it may actually raise the stakes of the disagreements over policy and decisional authority. The larger point here is that the federal system is still a closed system. Whatever pressure is relieved by state litigation has to go somewhere. I don't think it's fully relieved. I think taking a broader historical scope here might help. I thought of the line this morning from Stephen Pincus's presentation here. He said something close to the effect of revolutions happen when resistance is shut down, leaving revolutionary agitation as the only outlet, which is certainly true, but successful resistance can also build. And especially if this isn't a functional or an effective release of pressure, it can actually embolden resistance and further undermine long-run national claims of power, which may be the goal from some perspective. And again, I think a broader historical scope about how this plays out. I think you did a good job of making claims that are justifiable by the data you have. So that's certainly not a critique of the current argument, but as it moves forward, it might be relevant. Second, related to this, is what kind of federalism are we talking about? This is always the question for federalism, especially in the past several years as this debate has changed. The example that you give, and this is just one subset of the issues, and a real strength of Ernie's paper is how clearly it breaks down the different things we're talking about, not only vertical versus horizontal, but the different facets of state litigation, the different kinds of questions they can raise. So this addresses just one of those, which is in the context of individual rights. So he says, but some states permitted same-sex marriage. This is in the gay marriage context. Some states permitted same-sex marriage to go forward, and over time, the example of those new families helped bring about one of the most remarkable shifts in public opinion in American history. State-by-state diversity may thus break up rigidly polarized political patterns over time, even if state political cultures are not significantly more warm and fuzzy than the national one. And you said that litigation appeals to national norms, which I thought was very important. This is federalism for national ends. I think this connects to the polarization point, was that it's polarization for national ends. It vindicates a national good, which is a more stable and peaceful politics, but also in the long run, we are moving towards a settlement on gay marriage. That no settlement of diversity over same-sex marriage, I think, was contemplated. Scalia got that. Certainly in Lawrence, in Windsor, which was held against him, then in Obergefell. But I think it's a national result that is furthered by this devolution of decision-making authority. And so it's either protracted or convoluted nationalism, in some sense. I think and I think a broader historical scope would affirm some of that. So the true logic of the laboratories of democracy is not that we should allow multiple laboratories to keep experimenting in their own different kinds of science. It's to find the right answer. And once you find that right answer, it's to do something with it. At least for some questions. I think the hard question is, which things do we tolerate that kind of diversity over? So finally, to kind of answer my own invitation to look at this in a broader scope, this has to do with the nature of resistance and dissent in the American federal system. And to put it starkly, is this what it's come to? Has it come to this domesticated resistance? As is often the case in Ernie's paper, there's a lot of action in the footnotes. And he says in one of those, and you always have to read them closely, you'll benefit from them, but you get some great lines in there. One of them was this: today's California has taken up the mantle of resistance to national authority passed down from John C. Calhoun, South Carolina. And I thought certainly that can't be the case. But just yesterday, Carson Holloway published a piece called John Calhoun's California, as I'm puzzling through this. And as you importantly note, violence is all but off the table. And it's always that all but, right, that draws the attention of these federalism scholars. But there are some important differences that distinguish the case, and I think show how far we've come in, pick your time scale, but within the past several political generations. California hasn't contested national authority. Unlike Calhoun, South Carolina, nullification is not suggested. Instead, California has tried to prevent the enforcement or complicate the administration of national policy. The law that they passed makes it unlawful for businesses to cooperate voluntarily absent a court order in the enforcement of or working with federal immigration authorities. That's quite different from John C. Calhoun, South Carolina. I think you're right to draw that kind of connection because I think that's the extent of state resistance that's possible. That says a lot about how we've developed. It says a lot about the kind of federalism that we can actually have today. So if the solution is litigation, or if litigation is one of the solutions, is that conflict desirable? Is an increasingly judicialized federalism what we want? Judicialized federalism, in my view, exacerbates the focus on the division of authority between levels of government. What is lost is the role of politics in generating, expressing, and regulating the common interest and the exercise of national power, and the role of states in shaping national politics. And here the nature, the standing of the Attorney General is very important. I loved the way that Ernie unpacked that. It taught me so much about the function and the development, especially in the democratic valence of these figures. And this came up over dinner last night, so I'll just mention it briefly. Ernie connects the AG as an office or institution to the theory of the Constitution, saying the objection to partisan motivations for state litigation seems to be that they render that litigation opportunistic, but it's hard to say why this sort of opportunism is necessarily a bad thing. In Federalist 51, Madison says that we're counting on the selfish interests of particular officials to create incentives to protect the institutional interests of the various parts of the government. Opportunism, in other words, is the foundation of both separation of powers and federalism. And that's right. I think ambition and opportunism are important here, but it's connected intimately to institutional design. I think that's something that's under-theorized or taken for granted here is how does the AG fit into the separation of powers and the division between governments? Because once you begin pushing, you see this democratic function that it plays, this representation that's able to exploit opportunities within polarized politics. You see this executive function as well, collaborating in times with state governors. Then you also see this judicial function. So maybe this kind of effectiveness and this role that it plays should be deeply concerning because it touches on not only the rule of law, but also separation of powers and federalism. So how do we theorize or how do we locate this position within the broader constitutional system that we have? Finally, for the questions that I have for Adam. Here, I think that there's a natural segue from Ernie's argument to Adam's. And the first question, the largest question I have, is where do polarization and partisanship figure in this analysis? I think the story is told, even though there's a lot of it at play, it's not faced up to directly. And the brooding omnipresence over this paper, it's not stated, but it's there, is the deep state. And what I really like about this is that it's an effort to come to terms with what that means, some of the causes. I think it's caught between what approach to take. So the questions that I'll identify pick up on the opportunities ahead of you. So you say, in a very important passage on 13, in short, the modern civil servant would be a technocratic elite, loyal to his agency's expertise-centric mission. It is hard to imagine a state of affairs more likely to produce bureaucratic resistance against politically elected presidents and the officers they appoint to lead the agencies. I think that's right, but only partially so. I think it's only true if the president and his appointees are hostile to the technocratic mission of the agencies. This is where partisanship is so important. In other words, it's hard to imagine the state of affairs when the president is a Republican, right? So who's leading, what's the mandate, what's going on? It seems to me, and you noted this, the role that mandate or mission plays in this, that agency mandate or mission is the missing piece of this puzzle. In other words, we need to distinguish between the bureaucratic resistance we see in the Trump and Bush years to that of the Obama years. Broadly speaking, is resistance to Republican presidents qualitatively different from resistance to Democratic presidents? In this connection, I think we could learn a little bit more than we do in the paper from the history of the civil service, because the combination of party polarization and administrative governance calls into question the premise on which the modern civil service is based. If we've moved from party to expertise, or if we've moved through, you document, from elite service to spoils with rotation to neutral competence, that seems crucially disjointed with our politics today. And we can only get leverage on that if we look at the underlying question of partisanship, the values question that you gestured towards at the end. The second question, and you discussed this in your talk, but not in the paper, so I'll just lay it out there as an important question. Very happy to hear what you said about it. Was who's the audience for bureaucratic resistance? You give a very interesting discussion about the leaks in the EPA leading to Massachusetts versus EPA. And then immediately after that, the suggestion is made that there's a broader audience than what you said. And you said the foregoing focuses on ways that an agency's career staff's active resistance can affect public perceptions of the agency's policy. And I would just say, pump the brakes. I don't think the public was the audience here. But I think, and as you noted, there are different audiences, and I would resist painting with a broad brush. I don't think you do. I think you begin to break up the different kinds of agencies that we're talking about, the different episodes that we're talking about, because this resistance does appeal to different people. Does it appeal to public oversight, to congressional oversight, to, as you said, those who are being regulated? I think answering that question will clarify the kinds of resistance, the prospects for the resistance, whether we should affirm this or not within a constitutional system. So the question of audience. And finally, and largest, is how should we frame bureaucratic resistance, and what should we do about it? I think this is the central decision that must be made as the project moves forward. And I think there are three options. They're all related. I'll just lay them out. Should we think about it in the context of democratic theory? Do bureaucratic actors represent democratic will of an earlier majority in some way? You can make a Jeffersonian argument out of this, either for or against, as with most things with Jefferson. Is it a conservative or stabilizing force? You cite the Burnham book. There's also Herbert Storing's argument, The Problem of Big Government, which affirms administrative governance as consistent with the theory of the Constitution. Or should we understand this in the context of American political development? Is bureaucratic resistance the result of tension between the consolidation or drift of agencies and executive-centered party politics? Or finally, and maybe cheating by bringing them all together, should we approach this as a constitutional question? One that complicates but is inscribed in the three-branch system established by the Constitution. I'm partial to this approach because I think it gives democracy its due, but also incorporates the polity's other fundamental commitments and as they've developed. So those three questions, I think, are somewhat separate from the questions you identify, so there's a lot on the table. And I did want to end by trying, as much as I can, to bring these together, maybe a step back, because this is the one panel that addresses constitutionalism and constitutions directly, is to look at those questions and what these papers tell us about dissent and resistance within constitutionalism. So just two themes or questions. The first has to do with particular constitutions, the second with the theory of constitutionalism. So the first is, what kind of resistance or dissent can a constitution accommodate or sanction? More normatively, does a good constitution, or can a good constitution, tolerate rights of resistance, and to what extent? Here I think we can learn something from the broader practice of constitutional governance. I was very happy that earlier Aurelian mentioned the Brazilian constitution, what's going on in other polities. 13% of current world constitutions, that's 24 of 192 currently in force, recognize some kind of right of resistance. The vast majority, though, enlist that right for the support of constitutional government. It roots resistance in the service of or for the purposes of the prevailing constitutional order. Instructive here is Honduras. Their provision says the people have the right to resort to insurrection in defense of the constitutional order. We have also Germany. All Germans shall have the right to resist any person seeking to abolish this constitutional order if no other remedy is available. And there are similar constitutions. But a broader and more fundamental right of resistance is recognized only in a very small number of constitutions. And I'll just say that they aren't the most prominent ones. So we have East Timor, Ecuador, Mozambique. Portugal actually recognizes the people's right to self-determination and independence and to development, as well as the right to insurrection against all forms of oppression. Perhaps most relevant, though, to the American Constitution is the French Constitution. All these other constitutions that I've discussed are post-war constitutions, the vast majority of which are 1970s or later. The passage from the French Constitution is a holdover from the 1789 Declaration of Human and Civic Rights, which said the aim of every political association is the preservation of the natural and imprescriptible rights of man. These rights are liberty, property, safety, and resistance to oppression. But I'll note that this is still a right of political association, which might exclude or distinguish the cases, such as those that Doug highlighted. So while the French example is closest to the theory of the American Constitution, we must admit it's not in its text or structure. There are a host of provisions that are relevant. I'll skip over those. But the trend in like the modern trend in national constitutions, the American Constitution attempts to establish the constitutional order as the protector and guarantor of natural rights and of fundamental rights. This in turn makes the stakes of domesticated resistance or internal resistance that much higher. So the question remains, what is the scope of resistance that a constitution can be understood to accommodate on its own terms? So turning finally away from a particular constitution to this broader constitutionalism, how does constitutionalism itself relate to the question of resistance? Resistance is a reflection of underlying diversity. I think Doug's paper does a good job of documenting that, as all three papers do. And these are disagreements over the purposes of politics, the requirements of fundamental political values, and the means oriented towards those purposes and values. As a result, this resistance often implicates not just individuals, but also communities. So it reveals competing claims about justice, about the good life, and about how social life should be organized. Constitutionalism is a way to facilitate political society and collective action in light of these competing claims. For that reason, central to the enterprise of constitutionalism is the distinction between the constitutional people and the partisan people, between we the people, all of us, and those who make more specific or partial claims in the people's name. Incidentally, this is why populism poses such a threat to constitutionalism. Preserving this distinction is hard, especially in the context of polarization, but more so in the contexts that are identified here, where the polity is fragmented socially, religiously, jurisdictionally, and even administratively. The long-run consolidation of national power and culture can, I think, be understood in this context, as the development or playing out of a tension inherent in constitutionalism. The tension between the constitutional people and the partisan people heightens and emerges into political life as partisan commitments work their way into constitutional law and politics. So as this distinction between the partisan and the constitutional people is blurred, whether that concerns the constitutionality of same-sex marriage, the relative powers of national and state governments, or the scope of administrative power. So constitutional governance, and certainly liberal constitutionalism, requires a particular kind of constitutional culture, one that can distinguish between essential and non-essential commitments. That culture, in turn, is nourished by norms, institutions, and the virtues of moderation and prudence. Because I'm a discussant, I get to ask what that culture requires and not answer it myself. But I think it's relevant to all of the arguments that were made. And each of these papers highlights a different mode or source of resistance in the constitutional order, and in this way presents three test cases for the enterprise of constitutional self-government, showing the possibilities but also the threats of resistance. And while they show that there's some reason for optimism, they also show why these issues demand our continued and sustained attention. With that, I'll stop talking and open it up to questions from all of you, and you guys can answer any questions as you wish.
Or avoid them.
Avoid them.
Can I take a crack at if either of you can answer his questions?
I can answer. I thought you just went to the floor. But,
Yeah. If no one is, so people
I can answer a couple of those questions.
Okay.
How do we get a stable jurisprudence? There are two basic approaches. One is general religious liberty provisions, which have the advantage of covering all potential conflicts that might arise, and the great disadvantage of being quite vague in general and leaving everything up to judges under a standards. The state constitutions or the federal constitution say, don't prohibit the free exercise of religion, or don't interfere with religion or conscience in any case, whatever. Religious Freedom Restoration Acts set up a standard of substantial burden on religious exercise and compelling government interest in least restrictive means. And they don't control the answer to any question. And blue states answer hot button issues like the wedding cases differently from how red states are likely to answer them if red states ever get gay rights laws. Most of the cases under Religious Freedom Restoration Acts have nothing to do with sex or same-sex marriage. They're about Sabbath observance, they're about grooming rules, they're about churches feeding the homeless and the neighbors don't like it. My guess is most of you never heard of a Religious Freedom Restoration Act before the contraception cases, because they weren't doing anything controversial. And the proposed solution that I offered in the paper was an attempt to apply these standards of substantial burden and compelling interest, and there is a compelling interest in protecting the gay community. The other approach is specific exemptions targeted to specific situations. There are thousands of those on the books in all sorts of statutes, and they have the advantage that they can balance interests legislatively. Each side can know what they're getting. You can enact a pretty specific rule that is hard for judges to evade, although nothing is impossible for a judge to evade. And we offered legislative language to legislatures considering marriage legislation, specifically targeted to marriage. Most of it didn't get enacted anywhere. Bits and pieces of it got enacted nearly everywhere. And that's the other solution, but it's much more difficult. It's much better if a legislature can agree on it, but few legislatures can. It's harder to do that deal than to do some vague and general deal. I think the second and third questions are really variations on the same question. Isn't the gay rights claim here a lot broader and more important than the religious liberty claim? No, it isn't. These are both fundamentally, at their heart, autonomy claims. You say, if I want to have sex or get married, it has to be with a woman, and I say, no, it doesn't have to be. I have the autonomy to do it with a guy if I want to. The dignity claims flow from that, right? People are excluded from various activities, or excluded from in the bad old days, from the larger culture because of their exercise of that autonomy. As against the government, when it was the government discriminating, the gay rights claim really was about full and equal membership in a political community. As against widespread or pervasive private discrimination, it's about full and equal membership in the community. As against isolated religious dissenters, it's not about that at all. It's about being insulted by a view that you know is out there anyway, and it's about having to go to the second vendor instead of the first vendor. On the religious side, it too starts with an autonomy claim. You want us all to go along with this new regime of marriage? Well, I'm not going along, right? You do whatever you want, but I'm not participating. And what follows from that is a claim about exclusion from the community. And if you think the evangelical community doesn't feel excluded, disrespected, isolated, in a minority status, why were they so desperate they voted for President? Grab him by the pussy. They voted for 2 Corinthians, and I never did anything to ask forgiveness for. Abortion played a bigger role in that than gay rights issues, but they both, I think, played a role. This is a community that does not feel that it has full and equal membership in the larger community. It starts with an autonomy claim. The dignity claim grows out of that. And with respect to the particular conflict that I was looking at, as I said, the harm to the religious dissenter who has the misfortune to be in the wedding business, both in economic terms and in dignitary terms, is broader, wider, and more permanent than the harm to the same-sex couple. He has to either surrender entirely or he has to give up his business. So, the two claims are substantially parallel. They start with autonomy, they spread out to dignity, and the question is on how wide a front is your dignity threatened? And for the gay rights community, things have gotten a whole lot better over the last 20 years. And for the evangelical community, they've gotten considerably worse.
Yeah, Steve.
So I have a question for each of you. In one case, in the case of Ernie, I just want to press a little bit on one of Connor's questions, which I was also sort of to my head. So the question for you was, I just sort of checked. I live in this small little town in New England called New Haven, and we're a population of 200,000. We have exactly one wedding vendor.
Okay.
So I guess what I wanted to know, who sell wedding cakes, right? And I guess I wanted to know what is the threshold of, because I really like the argument, but I wanted to know if the exemption is going to be where you have more than one, how many communities actually, how many communities, what's the sort of demographics? This is just a sort of political,
Yeah.
And the question I had, I'm also, I'm very sympathetic to the kind of safety valve argument, but I guess what happens, if there's, it strikes me the sort of medium, so the short-term consequences, I'm completely persuaded of your argument, but in the medium term, if there's enough, it strikes me that this could lead to increased partisanship or increased geographical partisanship. That is to say, it strikes me that if you have some states in your sort of vertical cases who successfully contest certain kinds of regulation, that you might, it strikes me that the medium-term consequence is going to be to attract populations that are sympathetic to that, and people who aren't sympathetic are going to move. And isn't that just going to create deeper divisions in a certain sort of way? So I guess what I'm sort of wondering is but nevertheless, I'm sort of sympathetic to the kind of safety valve. So where are the limits of how much, instant pot pressure you can leap off without in fact, risking a significant harm to the polity as a whole? And I just don't quite figure out what the test is. So I have a terribly contrarian question for you. And this is not a question because I actually believe this, but this is just because, I was educated, I spent a lot of time going to school in Britain and watching Yes Minister, which sort of convinced me, so the whole argument of Yes Minister as a program was, expertise is good. And I guess I sort of see there as a sort of fundamental, I sort of see your argument that there's this fundamental conflict between democratically elected politicians and these non-democratically elected bureaucrats. But to what extent, I guess I wanted to sort of, for you to sort of take on more the normative question as to why, the distinction that you made between expertise, people sort of saying, yes, CO2 emissions cause climate change, but what to do about it, strikes me as, it strikes me that that's a difficult line to draw because there might be a balance on, I don't know on that particular issue, but that expertise sometimes say, experts sort of go the step further and say, well, there's this, we can have a debate about this realm of solutions, but up to here you need to go. So I guess I'm sort of wondering, why is expertise bad normatively? And where do we draw the line? To what extent, can we do that? So those.
I'd be surprised if you're one guy in New Haven is really the only one. I'd be more surprised if he's a conscientious objector on these issues.
What? There's small. You can certainly
Right.
go to a big supermarket and
Sure. Yeah. And I don't know what the demographics are across the country. Plainly, the gay couple needs more legal protection in the Bible Belt, and the evangelical center needs more legal protection in New Haven or San Francisco. And as I said, there are only a handful of litigated cases. In all of those cases, multiple providers have been immediately available, often for free, often by a referral from the conscientious objector. And the local monopolist is the hardest case because what we say to him really is you get the conscientious object as long as it doesn't really matter. Right. And the activity is going to go on anyway, but if you're the only one, now you're stuck.
That's a hard case.
Yeah, and I think that follows from, each side is entitled to participate in the marketplace. And if you occupy a blocking position, you do forfeit some of your rights. And you can get out of that blocking position without having to give up your business, although you might have to move. It's not an easy choice, but I've come down on the side of not protecting the monopolist. In the metropolitan areas where most of the people are, most of the gay couples live, I think there will generally be another provider.
What a great business opportunity. I want to open a bakery.
My kids would be very happy. I encourage you to visit them.
Wow. So I haven't responded to all your other questions yet, but I'll just do yours. So I think another way of putting your question is this just a road to sectionalism down the line? And I am very tempted to write an article called The New Sectionalism, because I think we are headed there in some ways. And so I think it's definitely a concern. I think sometimes these things resolve. I think sometimes once things are implemented on the ground, there is the system moves toward a particular policy outcome or not. And I think the same-sex marriage example really is one of those. So even though the court kind of cut the development short in Obergefell, which I'm not saying is wrong, but I think it implemented something that was happening very quickly in every single American jurisdiction. So I think that was resolving. I think there are other things that are likely to persist for a very long time. So the Economist had a cover story years ago, California versus Texas, and making the point that there were just fundamentally different economic and regulatory models in California and Texas. You had a high services, high tax, high regulation model in California, and low all of that in Texas, and that has been persistent for a very long time. I don't see radical conflict over that. I think, but there very well may be things like that persist. The division over right to work laws has been around for a very long time, not resolving. It does seem to me that the most catastrophic impacts of sectionalism occur when one or both sides think they're going to get a resolution at the national level, and they think they're going to be on the short end of that. And that's what caused the South to leave the fight, right? Because they thought not only are we going to be divided on this point, but it's ultimately going to be decided, it's going to be decided against it. So I think to the extent that we can create a stable constitutional regime that agrees to live and let live on some of these things that divide us, you can avoid that. I think the question is, can we create that?
Well, I'll answer your question first and then return to a couple of Connor's questions. You're right. Expertise is in general a good thing. It beats the alternative, right? Right, but as you noted, I see in very broad terms, not a dichotomy, but a spectrum, right? Of places where we're talking about pure scientific questions or pure technical questions and pure value choices. And of course, it gets messy in the middle. The whole time I was writing this piece, I sort of sensing the same question. I was haunted by a piece that Harvey Mansfield did for the New Atlantis a couple of issues ago, where he takes on the fact-value distinction. And I was worried that I'm bringing down the wrath of Harvey Mansfield by suggesting there is such a distinction. But I think, in large part, that's true. That on the whole, I'm calling for a better allocation of expertise questions over here and value judgments over here. An example I like is sticking in the context of energy policy. You all know now where I spent 14 years of legal practice in these issues. In the 1970s, at the height of the energy crisis, Congress recognized that they needed better expertise. They needed a better sense of what the actual facts were of energy policy. And they created a thing called the Energy Information Administration. It's the most boring agency in Washington, but it's also maybe the best. What does it do? Every day they show up to work, and they do their best to figure out what our energy resources are today, what they'll be a year from now, 20 years from now, and they issue reports and projections. And they're not gospel, but they're a nice sort of starting, or they're a credible first step in the policy conversation. And I wish agencies would do more of that. I wish we'd have agencies that were created to do specifically that, and leave, to the extent possible, policy questions for another agency to decide. But of course, it's easier said than done. Kind of, you kept pointing at the big picture. What is this really all about? Is it the deep state? I always sort of try to avoid. I bristle at that term. What I tend to think of as in terms of the managerial elite that Burnham was writing about, or sort of the new class that the neoconservatives were writing about. I think that's a good explanation of what's really animating this. It's not exclusively partisan, but of course it does sort of align. with basic partisan lines. The Democratic presidents that complain about bureaucracy tend to be complaining about inertia. Republicans are complaining about a mix of inertia and resistance. But in terms of the audience, to put a finer point on it, the resistors in a bureaucracy, I think they understand that they have a good constituency among Democrats in Congress. And by the same token, I think Democrats understand that they have a good constituency inside of the agency. I think that's important. But in all the audiences you identified, or the collective we've identified, the courts, Congress, the regulated community, I think it's important to note, we're talking about a conversation then among elites, right? Among the folks in the bureaucracy and judges, congressmen, the decision makers in business. So much of the resistance is seen as sort of populist, but it really is it's not about the public at large. It's a conversation among elites. I like the way that you sort of gave me some options, multiple choice. How should we think about this? Your first option, the Democratic will of an earlier majority. There's something to be said for that. Congress has passed these laws, and the way you phrase it, actually, you come close to quoting a D.C. Circuit judge from the 80s. There was a judge, Patricia Wald. She was appointed by Carter. And in the early years of the Reagan administration, before the Supreme Court pushed back against the D.C. Circuit, the D.C. Circuit was really giving the Reagan administration a hard time. And Patricia Wald said, after the fact, she said, we, the Democratic judges on the court, thought of ourselves as trustees for earlier Congresses. There's something to be said for that, because these laws are still on the books. But I think the way I tend to think about all this is the decline of Congress. That Congress wrote these laws a long time ago, and since then has lost the ability or the will to govern. They've created a policy vacuum, both through the lack of modern legislation and also through the point that Will made so eloquently in an earlier panel about the role of the power of the purse. Well, it's absent today in the way we structure our budgets, the budget debates, that it's created this policy vacuum, and nature abhors a vacuum, and so the agencies sort of naturally fill it. But at the same time now, I think the relationship works in both ways. I don't mean to filibuster, but I do want to make this point that it's not just that Congress is doing what it's doing over here and the agencies are doing what they're doing over here. It's that now the agencies are able to do things in a way that has its own gravitational pull on the legislative process. Right? Say under the current administration, Republicans in Congress know that if they don't get what they like in the legislative debate, they can walk away from the table and Trump's agencies will do it. Right? By the same token, the Democrats in Congress know the Republicans have no real reason to bargain. So why would Democrats preemptively make compromises? And so I do think the administrative agencies, the administrative states, reached sort of a critical mass where it itself deforms the politics, and to keep mixing metaphors, puts us in a sort of a bad cul-de-sac. I'm not sure how we get out of this. On that cheery note, I'll turn it back over to the question.
More questions? Let's get a couple. Rita and Danielle.
Yeah, so I guess I wanted to just push a question that I think Connor basically asked you, Adam, but to put it, sort of to maybe slightly different way, which is that if we think of bureaucratic resistance as a potentially useful thing, if the executive is really acting in this sort of unconstitutional way, and because he has Congress, the party sort of is, the party alliance is preventing Congress from checking him in the usual constitutional manner, such that we might actually favor bureaucratic resistance. Assuming that context, given the fact that so much of the bureaucracy's credibility and legitimacy is based on expertise, if it became partisan in this way, or it demonstrated this underlying partisanship, which of course we all know kind of exists, insofar as we know people who work for the administrative state and we know their partisan views, but they publicly tamp that down. But if they're sort of encouraged to publicize their underlying partisanship and their underlying sort of polarized position, does it undermine their bureaucratic positions, the sort of neutrality of the bureaucracy that allows them to have a position in the first place? I don't know if that exactly makes sense, but
Well, I feel like we're heading.
Is it a kind of pyrrhic thing that they would be engaged in if they tried to resist this way?
In a way, I think so. I think that's part of the story of the last election. I mean, the last administration, the Obama administration, you had an alignment of the bureaucracy that we're talking about, and an extremely energetic administration that used administrative agencies to really unprecedented lengths, whether it was creating national policy on regulating the internet, or creating a national energy policy through the Clean Power Plan, or all the issues that ended up raising all these questions of federalism and religious liberty through healthcare, health policy. I think that Trump's election was a reaction in some parts to that. In fact, at the outset of the Trump administration, I kind of wondered if these vocal calls for resistance would continue, because I thought that would be the only thing that would ever give rise to real civil service reform. That if the resistance persisted vocally for more than the first year, then you'd actually create the conditions for some of its own undoing. Things quieted down a bit, whether intentionally or accidentally, but I think that's where it was headed actually, was in some ways an overreach by the resistance that would have actually sown a backlash. Yeah.
So I'm wondering, in regards to the Masterpiece case, and I appreciate that you disregard the free speech argument. I think Floyd Abrams made the comments that the bakers in Masterpiece weren't being asked to differentiate their product, but to recreate their product, and therefore the speech argument doesn't hold well. But just engaging normatively with your argument and the autonomy argument, I'm wondering if you're willing to sort of, expand the scope of it at all, because if you're just engaging on the normative grounds, the home as a traditional concept is infused with religious ideas and traditional ideas. And if I'm a homemaker, can I, say that building a home for a gay couple would be a sign of supporting their cohabitation? Or also in terms of identity categories, if my religious objections are to miscegenation, is that then something that I can say is also a sort of a legitimate opt-out, as long as they go somewhere else?
Well, on the second question, I think race is constitutionally unique in our history. And I don't have any trouble with saying no exemptions on race. And the short version of that is, every other group tries to piggyback on the black experience, but nobody else experienced 250 years of slavery. Nobody else required 750,000 deaths and 3 constitutional amendments in a century and a quarter counting to try to implement those amendments. On the first question, I don't think that's a claim that's likely to arise. Maybe it could arise with respect to a custom-built house for a particular couple. In terms of the broad standards that we have to work with, the further this claim gets from core religious matters, the more attenuated the claim of substantial burden on religion becomes, the more skeptical judges are going to be. And the greater the government's interest in regulation becomes, because if the gay community is exposed to the risk of encountering discrimination in all kinds of transactions in all parts of their lives, that's a very different government interest than if we define weddings as religious and treat weddings as special. So it is easy to imagine broader and more attenuated claims, and they rather quickly, I think, become self-defeating. That's the reason I distinguish small businesses from big businesses. Big businesses, government has a greater interest in regulation, and the owner has much less of a claim that he's personally involved in violating his conscience.
Can I respond to some of your other? Sure, yeah, Nick has a question.
Well, I was more or less actually going to reiterate one of Connor's questions, and actually one that you sort of anticipated in the paper itself. On the one hand, I'm really sympathetic to this idea that public law litigation, it's like this renaissance for states and for federalism. Like, the states are suing the federal government, and if they're winning, it's a lot. We're alive and kicking still. Federalism's still a real thing. On the other hand, I'm wondering, is that how citizens themselves see it when California sues the federal government, or the federal government sues California, and there's this legal debate? Does the average Californian or does the average New Yorker see it as their state prevailing, and therefore perhaps this litigation or this judicial battle nurturing their attachment to the state, or maybe nurturing their kind of feeling of federalism, their belief that the federal system can produce good outcomes in the long run? Or is it just partisan? Is it, we got to try harder in the next election to get the Democrats at the national level so we can get that, so we can get this outcome everywhere and vice versa. It's the question that Connor posed. Is the ethos of uncooperative federalism really just another way of saying there's two nationalist camps in America right now, and they're going to use the levers of power that they have where they have. So the question is, you seem to hint at this type of forbearance at the states, like states and state litigants, maybe attorneys general, are able to exercise this type of political forbearance that when they get a devolutionary outcome, they might not. I'm just wondering, do we have an example, or am I reading you right, or if I could just engage you in this type of critique?
So, the last part first, which I'm afraid I'm going to forget, but I think it's separate. I'll answer first. Which I take as, do the states ever act in the litigation process to protect their institutional interest, even if it runs contrary to their policy or partisan interests? And my favorite example of that would be the brief filed by my friend Kevin Newsom in the medical marijuana case. Kevin was the Solicitor General of Alabama, and he files a brief on behalf of Alabama, Louisiana, and Mississippi in support of the pot smokers in the medical marijuana case. And it starts out by saying, if these plaintiffs lit up their marijuana cigarettes in our state, we would lock them up and throw away the key. We are so anti-drug, you can't even believe it. And we think what California is up to is nuts. But their right to experiment in that way is federalism, and we're here to support them. Right? And so there are cases of that. Not as many, but they do exist. So you're channeling basically Jessica Bowman-Posen, who wrote an article called Partisan Federalism. There's nothing of independent significance to the states, except just that the correlation of partisan forces is different within them. I think even if all that's true, they're still serving a very valuable role. I'm not sure I ultimately care all that much whether, well, I care, but I'm not sure how much other people would care, let me put it that way. Whether citizens feel some independent vindication because it's their state and they're proud of that when their state sues the federal government, or whether it's just, we've created an effective intermediary institution between the individual and the state in Tocqueville's terms to stand up for certain principles and act as a check on the center. I think states just compare pretty well to the other intermediary institutions that are on offer as part of that checks and balances. And I think I also think, relatedly, that as we change from a regime of dual federalism where the states have their own separate sphere of regulatory activity that's completely different from what the federal government does, and now we're in a regime of overlapping jurisdiction, the way that the states continue to participate in that scheme is by taking part in national politics in various ways, in national regulatory schemes, and this is one important way that they do that. But I do think that if there's going to be any kind of citizen identification with states, and I think that is important for reasons that are a completely different paper, I think states need to be able to articulate their values and articulate positions on the public issues of the day. And one of the things that this kind of litigation does is it's an opportunity for states to articulate those values in a principled way and air them. Right? And I think that is an important thing for states to be able to do.
Additional questions?
Can I say something about it? I found Ernie's paper so fascinating because for so much of my legal practice I was involved in the issues that tended to bring up states, whether it was energy or the Obamacare stuff or even the marijuana stuff. And one of the fascinating things I saw watching this happen for years was that a state, for these purposes, is not an it but a they, right? You have the state AGs and then the state governors. But something you might not think about, the state regulators inside of an agency, oftentimes they sort of align, if not with the sort of the national regulator, but with each other. Right? At the same moment that some Republican attorneys general were bringing lawsuits against whatever policy, say climate change, you have the regulators in the state going to the sort of national meetings for National Association of Clean Air Regulators, and they would sort of think of themselves as a block their attachments were more with one another than with the state, in the same way sometimes state AG's attachments are more with one another with the states. And so it becomes a really interesting case where you have 2, 3 entities within a state, just within the state's executive apparatus, in some ways representing interests of the states. It gets very messy and very interesting.
Right, well, states generally don't have unitary executives, so you may have the governor and the attorney general being of different parties, and you may have fights over so in the Obamacare litigation, for instance, a bunch of states participated, mostly through their AGs, but some through their governors, and there was one state, I think this is the Obamacare litigation, where you have participated by the same state on both sides, right, different officials. There's a great case out of Virginia, I think, where the question is, can one agency of the state sue another agency of the state? Right?
In federal court.
Yes, in federal court. Not based on diversity of citizenship. So those are fascinating questions. In North Carolina, we have the situation where the legislature is constantly trying to rein in the attorney general, because they're different parties. And those add a whole additional element of complication. I do think all of that is basically, at the end of the day, to the good, because if you think about states as just one of a menu of institutional options for representing broad and diffuse interess, the checks and balances that are built into state constitutions and the democratic accountability of the officials bringing these suits, it compares so favorably to the checks on plaintiffs' attorneys in a class action, or the checks on the leadership of the Sierra Club or the AARP when they bring litigation on behalf of their members. You're much more likely to actually get meaningful political responsiveness out of the states. I wanted to answer your question about the safety valve, because I think this is an important point. And the point was that the most obvious beneficiaries of these are the people who are losing at the national level but might win at their state level. And I think that's true, but they're not the only winners. The first point is just that we all lose from the fact that the national government is incredibly polarized and incredibly gridlocked and unable to do anything. Right? So if the ultimate point is take the most divisive issues off the national agenda and devolve them to the states and hope that the issues that remain can actually be dealt with. But I think that's realistic, especially because the most polarizing issues are the social issues. Those are the ones that are most likely to be outside the proper cognizance of the federal government, most likely to be devolved, and they're the ones that are most varied by geography. Right? So if you take those off the national agenda, you're both more likely to get a consensus in individual states, and the issues that remain, the polarization situation, is just not as bad at the national level. So I think everybody benefits from that. But I think everyone also benefits from playing the long game here, because the national losers at any given moment are likely to be the national winners the next time around, and the time horizons don't have to be that long. And so everyone has a benefit from a stable allocation of authority that is likely to please more people. And then you worry about the people who are minorities within their states, but majorities at the national level, right? And I think that there's a lot here for them too, though, for a couple of reasons. One is that they can move, and people do move, and the evidence on migration and mobility is increasingly that people are making moves of choice rather than moves of necessity. It used to be that interstate mobility was the Jones moving to California not because they want to, because they have to, not because that's a more legal regime more in line with their values. Right? But now it is. That is why a lot of people move. But
It is deeply, deeply scary.
Yes, it is. And I think you're likely to have less losers, right, because you're satisfying more people at the same time. But the main thing is, I think there's a greater hope of less polarized politics at the state level, because there's more trust in government that leads to bipartisanship, because they're less closely divided, which changes the incentives for behavior, and because the state governments have to deal with all these kind of bread and butter concerns that aren't particularly political and exercise kind of a calming influence on things. So. But I don't think it's so bad, even for the people who are left out.
In the interest of getting questions on the table, Stephen and then Will, and we'll get those, see if you have time to answer them.
So I guess I was going to sort of follow. I was trying to think about precisely this issue, and I mean, it strikes me that the safety valve argument runs into problems if you're simply replicating, if the partisan divisions at the national level are being simply replicated. And I mean, I think your argument about social issues is very powerful, but it strikes me that environmental issues and trade issues are two issues that are increasingly polarizing, and those, it doesn't strike me that you can take those off the table. I mean, it's very difficult. I mean, it's very difficult to sort of see, were we to get into a trade war, how this would only affect, you know, one set. Whereas I completely agree. I mean, I think, and so I would wonder whether you would sort of want to make a radical distinction between social issues, where I take your point. I think it's extremely plausible that you sort of that you can sort of diffuse issues by creating different kinds of consensuses or different kinds of, I mean, not consensus, accommodations based on regional or cultural differences. But it seems to me less likely about environmental issues or about trade issues. And so I guess I'm sort of worried about that.
I think that's basically right, and that's why I wouldn't say that, you know, horizontal litigation over control of national policy should always be off the table. I will say, I think most of these things aren't as inevitably national as it seems. So Peter Spiro's done some work on the foreign relations aspect and points out that a lot of trade sanctions now by foreign countries are in fact targeted at particular states. So Mexico targeted California after Prop 187. I think just recently the Europeans targeted some red states because they thought they were the ones that were driving the bad policy. So it's not impossible for this to break down a little bit. But I think generally speaking, you're right about trade. On the environment is a tougher question because that is the stock example of something that has to be done nationally because of spillover effects and all that. But what's the first thing we do in administering the key environmental statutes, right? And that is that we set national standards for pollutant levels, but then we delegate to the states to come up with implementation plans. So we immediately create a system of federalism within the federal structure of the environmental laws. So I think there's more room for that to be devolved than you might think.
We've already run over by a few minutes, so to respect people's time. Do you want to wrap up? We can continue the conversation over dinner. Rita may have some final words, but
Yes.
first, do you want to thank the panel first?
Yes.
Okay.